Good evening and welcome to this year's Legal Aid Billing Seminar organised by the Bar Council. Before I introduce our speakers for this evening, I just want to make you aware of a few things. First of all, after the presentations, the speakers will be able to take questions from you. You can post your questions anytime in the question and answer box. This session is being recorded and will be made available to watch when the webinar has finished. Live transcription is available and can be enabled by clicking the live transcription button at the bottom of the Zoom window. Just a short introduction then in relation to our speakers this evening, and we're very lucky to have back again to speak at this annual billing seminar, Rob Damiao. Rob has been with the Legal Aid Agency for a very long time, about 14 years. And he is an operations manager. He's based in the civil billing team, and he oversees the areas of Bristol, Cardiff, Leeds. And part of Rob's role is to liaise with the legal aid providers, barristers, representative bodies, and organisations like us, and provide talks to events such as this. Rob specialises in civil family cases, and there isn't very much, frankly, that Rob doesn't know, and he's always a mine of useful information and tips, and you'll hear from him shortly. But secondly, and by way of introduction, we also are very privileged to have Scott Baldwin. Scott is a senior clerk who I know very well, and he is at St John's Building in Liverpool. He's been a clerk for 34 years, and Rob is in one of the largest chambers in the country with a team of 108 barristers and 8 silks. Rob is on the Bar Council Remuneration Committee. He also helps with the Institute of Barristers Clerks and the Family Law Barristers Association. He is a great knowledge on legal aid billing. Rob is incredibly helpful to all of those organisations, and he works collaboratively with the Legal Aid Agency, specifically on the high cost cases. And he has helped and been contributing to improving the processes and drafting the guidance for the profession for some years now. So we're very grateful to both of you for making your time available to us this evening to speak. The order of speakers is that we're going to hear from Scott first of all, and he is going to speak on high cost family cases and the tricky bits, and he'll tell us what the tricky bits are in a moment. And then when Scott has spoken, we're going to hear from Rob, and Rob is going to speak on a number of things, including family hourly rates, rates for claiming for appeals, and supporting evidence. They are going to share slides with you as we go along, so sit back, relax, and Scott, over to you. Thank you very much.
Thank you very much. I will share my slides, which hopefully will work seamlessly when I press this button. It says it's working, so hopefully that's all okay. So yeah, the topics for both of tonight's, this afternoon's even, sessions came primarily from fees clerks. The FLBA, the Family Law Bar Association, set up a mailing list for fees clerks sort of towards the end of the pandemic for the sharing of best practice and to ask questions of each other. And so a little while ago, I asked that mailing list, what would you like to hear about? And so the 2 sessions have come about largely from those, so this should all be largely relevant. The bulk of my session is around care cases, because that makes up the bulk of high cost cases. I will touch on other types of high cost cases. I'm not going to go over all of the regulations because there's far too much of it. I'm just going for the key tricky bits that you've asked me about. So on to the first bit, which is 2 council cases. So the starting point in these is to apply to the LAA4 authority for 2 council. Usually we're talking here about KC and Junior, but there are a couple of other variations. The guidance on that can be found, as can all of the legal aid high cost guidance, on that link there. If after this session you lose the slides, which will be circulated afterwards, and you can't remember it, if you Google LAA high cost family, it's the very first result in Google is that link. Now, the guidance itself about To Counsel has got that rather natty title, which doesn't really tell you what it's about. So that is quite helpful in knowing that that's what it's for. And it's just the Bible on how to go about applying for KC or To Juniors. So the different types of To Counsel cases, the one that most people will see will be KC and Junior. That's the most common. That's the general criteria that's features in that guidance. There's far more detailed guidance about what that all entails in that guidance that I mentioned earlier. One tip that I would say to you is make sure that you apply for KC and Junior. That's authority for KC and Junior, because if you apply just for KC, the LAA will grant you just for KC and Junior will lose out and no longer be instructed. So you want to make sure you get that bit right. To Junior Counsel, this is an interesting one because it's all about the amount of disclosure. So if you've got a case with lots and lots of pages of evidence, there's a good chance that if you follow that guide there, that you'll be able to apply for To Junior Counsel. And the last one is kind of an add-on. It's not really a standalone. If you've got a case where the LAA have granted authority for KC and Junior, they will, if you can't find a suitable KC, you know, if it's short notice listing, they will allow you to substitute a senior junior in place of the KC, and they get enhanced rates beyond the normal Junior Counsel rates. But as I say, you can't just apply for that. You have to apply for KC and Junior. And if you can't find a KC, then you can opt for that other option. So what rates apply? Obviously, if the hearing date is 11 days or more, we all know this, then events apply. When events do apply, all previous fees convert over to events rates, so everything gets boosted up. They're the different rates that are there, and as you can see there, I mentioned the senior, junior and junior, slightly higher rate for the senior junior if you manage to get one of those. Don't mix up the To Junior Counsel and the senior, junior and junior, because if you do and you end up claiming a POA for far more than you're due, you'll have to pay it back, which nobody likes. When it's less than 11 days, KCs will always be on FGF rates because there are no KC rates in FAS. Juniors get the option to choose either or, but it has to be for all the hearings. So you can't have one hearing at FAS rates because it pays better for that one and one at FGF. They're all FAS or all FGF, but you do get the choice. This is the crux of quite often why you don't get paid in high cost cases. When it's registered as high cost and authorities granted, the LAA will automatically grant in single counsel cases a cost limit of 32,500 and in To Counsel cases of 60,000. So in a single counsel case, that's normally enough for you to claim POAs to the end of the case. Obviously, if you get an unusual case where there are lots and lots of hearings or there's a very, very long main hearing, then it might not. But the vast majority, you know, if you're talking 15-day combined main hearing length, this will probably cover you. You'll probably be okay. For To Counsel cases, and specifically KC and Junior, really, I'm talking about here, if it's on events, you will need an interim case plan. I'll explain more about that in a moment. If you're on FGF FAS, so you're under 11 days, this will normally cover you to the end of the case. And then finally, fully costed case plans. There is no standard cost limit for these. They're agreed in stages throughout the case. They're a pain in the neck. You have to be prepared to give cost estimates for future work as it goes along and keep the solicitors updated about the costs as they're running. I'll explain a little bit more about them a bit later on as well. So going back to the 60,000 limit in To Counsel cases, and this is an illustration of why you will need to increase the cost limit straight away. The total cost of KC, Junior and Solicitor comes to £4,374 per event, which means that in 14 events, you've swallowed up that £60,000. So to get it to be events, it needs to be 11 days to start with or more. So that only leaves 3 other events at the very minimal level, which is next to nothing, as you know. If, as often happens, there've been a number of events before the KC comes on board, then you also got to factor that in. So 6 events with Junior and Solicitor is £14,000. So you will always need to do an interim case plan on these. So the trick really here is to get on it straight away. As soon as authority has been granted for to counsel, Casey and Junior, get in touch with the solicitors, get in touch with the cost lawyers, and send them a cost estimate and get them to put in an interim case plan. Otherwise, you won't be able to claim a payment on account, usually at the end of fact finding, which is when the sort of the big POAs come out. Yeah, speed is of the essence, really, with that. Family graduated fees, and this is the one that catches everybody out, and I've called it the forgotten fee scheme because a lot of people will never have used it, and those that did have probably forgotten how it worked and all the subtleties of it. It was the precursor to FAS, so if you know FAS, it's very similar in many ways, but there are some different parts which can catch you out. And one of the biggest problems people raise is that the LAA won't pay me. And the reason they won't pay you is that the case plan or the final bill is incorrect. And it's so easy to get something small wrong with FGF, which means that tens of £1,000 bill will be held up because of a couple of £100 somewhere buried away in your FGF claims. So it's really important to get this right. There are 4 main categories of work. Public law children is the one we're focusing on because in reality, the other areas rarely come up, if ever, in FGF anymore. Be very careful if you're using old guidance because the rates predate LASPO, which is when the 10% reduction across all legal aid rates came in. So it may well be that you're looking at rates which are now out of date. Those of you that use LEX and MLC to calculate FGF, those will be correct. There's an option for the FGF minus 10%, and it will calculate it at the correct rates for you. As I said, that it's very similar to FAS. It was the precursor to FAS. So there's a fee for advice written work. There's a fee for conference, interim hearings, fact findings and final hearings. There are also a couple of other weird bits. Enforcement, F2, it's not really used anymore. A lot of the enforcement things were for committals, which have now come out of family legal aid and now in criminal. So they're very, very rare, and you can largely ignore them. The only other weird bit is advocates meetings. They count as hearings in FGF, so slightly different way of billing, but largely the same. So F1 and F4, the advice and the conference. Fee is per item, so it's not based on a length of time involved, it's just per item. And as with FAS, there's a limited number of each that are claimable. F2, I'll just ignore it, but if you did for some reason get an F2, it's paid as 2.5 hour units, the same as F3, so it works the same way. And as I say, F3 paid in 2.5 units or part thereof. There is no 1 hour unit as you find in FAS. It's all 2.5 hour units. And that applies to advocates meetings. If you get an advocates meeting that goes over 2.5 hours, I think you're doing something wrong. So you can probably ignore that too. The one really tricky bit about F3s that's different from FAS in FGF, and this is the one which will catch you out, is if the court sits beyond 5 p.m. on an interim hearing, you don't get paid anything for after 5 p.m. for a multi-day interim hearing. If it concludes that day, so it's just a CMH that runs beyond 5 o'clock, the clock stops and you get a half a hearing unit fee, so half the F3 normal fee on top of your fee, which is completely different to FAS, where the time just keeps running. So that's one thing that does catch people out, so be aware of that one. And then for F5, the final hearing or fact finding, fee paid per day, as with FAS. There's a slightly higher rate for the first day for the F5 primary. You can only claim that once. You can't claim it once for the fact find and once for the final. It's once for the entire main hearing. You can claim the IRH or the PHR as F5 primary. You might want to play around with that a little bit. If there were several units, several 2.5 hour units, if you were claiming it as an F3, it might pay better than if it's the F5 primary. So put it through your calculator and see which works. But a note of caution there, it won't count to the length of the main hearing. You can't have a 10-day final hearing and then claim the IRH and make it 11. That doesn't work. And then the F5 secondary, that's paid for all the refreshers, and that's just a slightly lower rate than the F5 primary. So this is where it gets a little bit different. SIPs, special issue payments. Same as FAS, the bolt-ons in FAS, they're paid as a percentage uplift to the function fee. They're paid per unit, the same as in FAS, and they can be claimed as often as they apply. The big difference with SIPs is that they are applied to all functions, not just hearings, so you can claim them for advice, conference, advocates meetings, everything. One slightly different bit is that the conduct, SIPs, the harm conduct, which in FAS is only claimable if it relates to an allegation made against your client, that is claimable by everybody in the case. If there's a significant risk of harm to the child, everybody in the case can claim it. If you're also representing the parents or the perpetrators against whom those allegations are made, you claim an additional 25% on top of that. So there's a sort of double bubble on that. Then there's special preparation, which is the thing that can make the big difference for FGF cases, the more complex ones. There are the criteria there: exceptionally complex cases, public law, where the main hearing is split and there's a 4-month gap between fact-finding and final. And the last one being the most common probably is the court bundle is more than 700 pages. So clearly, if you've got a 2-counsel case, which is complex, the bundle is going to be more than 700 pages. Just a quick pause for a sip of water, excuse me. So those are the rates there, claimable per hour. I'll explain how to claim it in a little while as we get into it. But special preparation and SIPs really, but special preparation can make a huge difference to a case. Bundles, bolt-ons, incidental items and other bits and bobs. So the court bundles they're there. This is where it differs again from FAS. These can be claimed as often as they apply. There is no limit to how often you claim these. They're claimable for all functions again, so they're claimable for advices, for conference, for advocates meetings. If you are putting in a special prep claim because the bundle is over 700 pages, you can claim the CBP2 in addition to the special prep claim. So both are claimable at the same time. And then there's a little one at the end there, the CMH bolt-on. So if a case is listed for a CMH, you can claim that additional fee on top of the fee. It's not mega money, but if you get half a dozen CMHs throughout the life of the case, that adds up. So don't forget to claim that. It's well worth having. Another one that makes a big difference is the High Court uplift. For any hearing which takes place in the High Court, you can apply a 33% uplift to the hearing units and the SIPs. It doesn't apply to all the other extra bits and bobs of bolt-ons, but it plays on for those. The travel is the same as all other legal aid. It's if there's a local bar and if it's you have to provide receipts if it's train fare and hotels, etc., etc., etc. The big difference though there is the audio and video evidence. So you can claim £10.90 per 10 minutes per tape. So if you had 3 2-minute videos to watch, that isn't 6 minutes of evidence. So £10.90, that's 3 times £10.90 because you get £10.90 per video. So if you've got a case where there's dozens and dozens of video, this can very rapidly rack up a few extra quid. It's not mega money, but it all counts, doesn't it? So how to do it? There's 3 different methods and I've put them there. You can provide your justification to the LAA. The problem with that is as with most of us here this evening, most of you will have forgotten FGF or have never used it. Most of the LAA staff are in the same position. So they might make mistakes. They might reduce things that should be allowed. And also it's up to them. It's subjective. It depends what justification you've put and what they think's reasonable. So I would steer clear of that if you can. You can use a SIPS form. For those of you who don't remember FGF when it was around, it's the same as the FAS or AA form in FAS. It's a form you have to get signed and sealed by the court to prove that you can claim these uplifts. The benefit of the SIPS form is it won't be reduced by the LAA. It's been ordered by the judge, so they're happy that it complies. The downside is that it's not part of the normal part of the final bill, so you'll have to remember to make sure it goes in with the final bill when it's uploaded to CCMS. You'll have to make sure the solicitors make reference to it in the case plan so it's all covered. So the best method is to add a recital to the court order. We do it in FAS. Everybody's used to it. It's the best way to go. The LAA prefer it if it's in the order. Clerks prefer it if it's in the order. Solicitors prefer it if it's in the order. So just put it in the order. It's the easiest way to do it. You can guarantee that way it will always be included in the final bill because solicitors have to upload all the orders when they put the final bill in. So there's always going to be that justification. There's no risk of your fees being reduced. I've put a suggested recital there for the order. Don't worry, the slides are being circulated afterwards, so you can copy and paste that. It does work on the basis that you have also put a FAS recital before this, which puts down the breakdown of times if you are on an interim hearing. So if you don't have the fast recital before it, if for some reason everybody's decided they're all claiming FGF, you'll have to put the times in somewhere, but there's scope to add that in, you know how to do that. So other tricky bits, hopefully that covers off all the FGF bits, but we've got the Q&A later if you've got any more questions. So other tricky bits, and there's a few. So in the two different event scheme, single council and two council, there are a couple of weird bits that are different. The vast majority of it is identical, except the rates are slightly different, but there's a couple of weird bits. The first one is advocates meetings. Single council, you can claim as many as are ordered, as long as they're ordered in advance by the court. You can't order them retrospectively as you can in FAS, but you can claim them as often as they apply. Two council cases, only two are claimable per advocate, where ordered in advance by the court, per part of proceedings. So KC, junior and solicitor can all claim two prior to the fact finding and all claim two prior to the final hearing. Slightly different, it's weird, it's the way that the system, the two fee schemes were all priced up. Single council was based on FAS, two council was based on FGF, and they were slightly different rules for both, so that's why they're slightly different. The same is true of written submissions, slightly different rules. So in single council, as long as the judge orders that one of the main hearing days is set aside for the preparation of written submissions, then you can claim an event fee. In two council cases, the main hearing has to be listed for more than 10 days, and the judge has to substitute one of those main days from that original timetable with a day for the drafting of submissions, and then only one of the two council can claim it, which will usually be your KC because they get the higher fee. The other council can claim an underrun, which is fine. But if it doesn't fit that criteria, then you can't claim anything because it's not a court sitting day. You get zip. So that feels a bit cruel, but that's the way it works, unfortunately, in two council cases. And it's because of the way it was based on the old FGF dregs. So the last weirdy bit between the two event schemes, two council, the rates are paid regardless on the level of the court, high court or county court, it's exactly the same. In single council, if the case concludes in the high court, then there's a higher rate of events that you can claim. So the standard DJ-CJ rate is 981, the high court rate is 1026. So it makes a big difference over the course of 20 or 30 events, but the case has to conclude in the high court. It can be in and out of the high court as the case goes on, has to conclude in the high court. This one is a horror story if it happens to you, and it can happen. The trigger for high cost cases is that the costs are expected to or actually do go over £25,000. That is barristers' costs, solicitors' costs, experts, disbursements, etc., net of VAT. So what will happen normally is as a case is sort of zipping along, the solicitors will recognise the costs are going to go over 25,000 and they'll register as high cost. If something then happens and the case collapses and it all goes short, there's a risk it might go below. Now, if no high cost contract has been signed and no council acceptance form has been signed, then the LAA will deregister it. We revert to the lower fees, which for junior council will be FAS. For KCs, they'll agree the fees on an hourly rates basis, provided no fees have previously been agreed. If, however, the contract has been agreed and signed and council has signed the CAF, then the LAA say it remains a high cost case. All the case planning has been done, it's all done, so the rates remain as they were. So it's really important for clerks to make sure that chase up the solicitors to make sure these things are being done. And for barristers, when the clerk sends you one of those council's acceptance forms, don't sit on it, do it straight away, get it back in, because it could be really important if something collapses in your case. One other word of note of caution on this as well is that another thing that catches people out often is cases where you're acting for an intervener, where the intervener comes in very late in the day, just before the start of the fact finding. They won't have contributed to, or their certificate won't have contributed to any of the experts' costs. There won't be any disbursements. There won't be any of the prior costs that have gone on for everybody else who's in the case. So there's a good risk that they won't get over the £25,000 case cost limit to become a high cost case. So you can be in a 15-day case acting for the intervener and be on FAS, and everybody else in the case can be on events rates. It's horrible and it's not nice, but it's better to find out that way than to put in a payment on account for all that, get overpaid massively, and then have to recalculate your fees and repay the difference through a recoupment later. So it's definitely one to watch out for. If you're acting for an intervener, keep an eye on it. Fully costed case plans, the bane of everybody's life who work in legal aid family. They're horrible. Everybody hates them. Fees are agreed in key stages based on estimated fees or actual fees, depending on what's happening. Far much more complex than and time consuming than care case. The fee schemes are all dependent on the type of case. So private law, financial remedies will be FAS. International child abduction, inherent jurisdiction, wardship are all on hourly rates. Once it becomes high cost, the high cost team have to go back through everything line by line and assess everything. So that's your prep times. If you put in 20 hours prep for a directions hearing and not explained why, they'll ask you why and they'll reduce your fees if you haven't done it. If you charged higher rates and not provide justification, they'll knock you back. So it's something to be aware of in these types of cases. If the solicitors tell you it's going high cost, get your justification, get all your ducks in a row. One really weird bit is child abduction, inherent jurisdiction, wardship. They escape fast, so they will normally be billed at hourly rates. But these types of cases, quite often the type of thing where you'll get a leader, you'll get a KC in, so it becomes high cost to counsel. And then FGF will apply if it's under 11 days, unless the LAA consider it to be exceptionally complex. So in those circumstances, they'll apply those hourly rates. So you have to justify that. It's a very high threshold on these cases because these cases are generally complex. It's got to be exceptionally complex, but it's something to kind of watch out for on these things. Another word on that in a moment, because there are other things that you can do if you find yourself in that position. So these are my last thoughts on tricky bits. Everybody gets things wrong from time to time, even me, as brilliant and clever as I am. The LAA will get things wrong, solicitors will get things wrong, cost lawyers will get things wrong. So don't be afraid to push back. The way to do it is to make sure you know your stuff, quote the regulations, quote the guidance, make your case properly, provide an illustration of the impact on the lower fees. You know, if your fees are going to be massively reduced because of you have to claim at a lower rate, then provide them an illustration of that. It won't always work, but in that example before, the inherent jurisdiction child abduction one, the LAA can be amenable. There's some wiggle room there. So ask and see what you can do. But it really does make a big difference if you can say, on hourly rates, I'm £5 better off than I am on FGF, and I've already claimed payments on account and blah, because I've done the work as I've gone along. It's only as the leader's coming at this last minute that now my fees are being impacted. So it's worth raising that and seeing what you can do. On the flip side of that is don't try and claim something that you clearly can't. Don't try and manufacture 11 days when it's not really there. Know the regs, be sensible. And the last one is just common sense. Be polite, ask nicely. If you send in a ranty email saying you've reduced my fees, this is ridiculous, you're not going to get very far. You're going to get somebody's back up. So be nice about it. Explain why you're in that position, explain what it is that you're looking for, ask for assistance. You'll be amazed how much more of a nice response you get when you're nice in the first place. And then there's a last bit from me on kind of how you approach these things, and this is the way that my brain works. So there's a Terry Pratchett character called Sam Vines, and he says, "Oh, I always assume that I'm dead wrong," and so that's my starting point. If I'm going to go to war on something, my first thought is, I've got this wrong. I go back and I reread all the regulations. I make sure I kind of sit on it and stew on it for a little while and think. And then if I really get stuck, I'll ask somebody else. You know, especially for you fees clerks, you've got that FLBA fees clerk mailing list. People put queries in there all the time. It's so useful, and it's useful for all of us, even the ones of us that answer the queries often. Sometimes you get stuff that we just don't know the answer to. So these things really do help us. They're really good. So that's it for me. There is a very last slide with my contact details on, but you don't need that now. So I will stop the sharing and bring myself back onto the screen. So that was my session. Hopefully that was useful. As I say, any questions, stick them in the Q&A and we'll get to them later. Thank you very much.
Thank you very much indeed, Scott. That was really helpful. Over to you, Rob.
Lovely. Thank you, Scott and Shiva. Right, everyone bear with me because I am from MOJ and we are a Teams organisation. So I just need to make sure that I'm using Zoom properly. Right, that should be fine. My slides should be up on screen now. Firstly, just wanted to say massive thank you to Shiva for a very lovely introduction, very kind words there. I'm very happy to be back. Obviously, it's been a while since I was able to attend one of these seminars for Bar Council, but I'm really happy to be back. Always happy to engage with legal aid providers and barristers as well. Before I get started, let's address the elephant in the room. Obviously, we have had 4 months of system outage, and I think it's fair to say that we're really sorry about that. It's not great. It's been really difficult, and we really recognise and understand the challenges that the legal profession are going through as a result of, in particular, the outage of civil systems and the contingencies we've had to stand up. So we're sorry about that, and thank you for your patience with us as we work through it. I can assure you that we have got colleagues on the digital team who are working incredibly long hours at incredible pace to make sure that service delivery and service restoration is delivered on time within the next couple of weeks, so that we can return to a semblance of normality. And a big thanks to the Bar Council as well, who have been holding conversations with us throughout about, in particular, the average payment scheme. And big thank you to for their engagement and feedback. It has influenced how the scheme is operating. It has influenced on what we're going to do with the recoupment schedule as well. With that in mind, obviously I'm here to talk about civil legal aid billing, but I am happy to take questions about the average payment scheme and about the recovery, anything like that. If you've got any questions, do please feel free to put those in the chat. But I will be upfront and say there are obviously certain things that we're not going to be able to address. I'd love to be able to sit here and give you a date for restoration of system access, but I'm not in a position to be able to do that at the minute. And likewise, questions about potential for any reimbursement of lost costs or anything like that as a result of the cyber attack. Again, I'm just not in a position to be able to answer any of those questions. But anything practical about average payments or recovery, please do use the Q&A function, and we'll try our best to answer those questions between myself and my colleagues Nick and Catherine, who are in the chat as well to assist. So without further ado, I will move into the main event. So today I'm going to be talking about 3 main topics really. Firstly, hourly rates cases in family proceedings and what you can claim. We'll be talking about rates to claim when you're appealing a family order as well, and what supporting evidence to submit to LAA to make sure that we can pay your claim first time, make sure that we're paying you as quickly as possible. So we'll start with family hourly rates cases, and the bare bones, what is covered. So what is excluded from FAS and is therefore payable at hourly rates. A full list is available in the civil contract, but I've got the list here, and we'll highlight probably the main ones that you're used to. The big one, representation of children in private law. So, if it's a child subject to a CA or contact order or resident and you're representing the child, then it's excluded from FAS and paid at hourly rates. It's quite interesting, this one, that it doesn't discriminate about the status of the client in proceedings either. So, for example, you could have, very sad situation, but it does happen. You could have a 16-year-old girl trying to escape from an abusive relationship and seek protection of non-molestation order or a DAPO. They would be defined under the contract as a child because they'd be under 18, and therefore remuneration for any work undertaken would be at hourly rates for that client. And of course, the other big ones, you've got child abduction proceedings as well, anything heard by the inherent jurisdiction of the High Court. And applications for forced marriage protection orders and child abduction proceedings too. And I think the only one missing off this list as well, a relatively recent addition, is female genital mutilation protection orders as well are included as hourly rates exempted from FAS. But it's not all just individual proceedings. There are specific services that are excluded from FAS as well. So anytime you're undertaking some of this work, it would be remunerated by way of hourly rates. Anything where there's an individual case contract for our very high cost case, which Scott has just talked through as well. Work undertaken by King's Counsel, acting as such under a prior authority again, and work in relation to any appeal against a final order, or if proceedings were to reach the Court of Appeal or Supreme Court, again, they would be remunerated at hourly rates, and we'll cover these scenarios later on in the presentation as well. So, how do you calculate the hourly rates payable? This is probably one of the most complex parts of family legal aid, and it's a pretty competitive field to take that honour. Essentially, there is nothing laid out in statute for specific hourly rates where cases are excluded from FAS. What we have is the contract, and I've taken the excerpt here from the 2024 family specification, which does confirm that although there is no hourly rate, when making an assessment of what is reasonable, we will rely on what we would either have paid a provider or a solicitor to have undertaken the work, which is laid out in the legal aid remuneration regulations. And we can have reference to the family graduated fee scheme as well. I do like Scott's name for it as the forgotten fee scheme. I think that's probably accurate, and we'll get into that in a little bit as well. But yes, it's you may find, as Scott has said, this is probably one way you may find caseworkers at LEA may make errors on assessment. It's simply because of the age of the scheme. FGS were rolled out in 2001. I won't tell you what I was up to in 2001. It's fair to say I hadn't even started university yet then. And they were replaced by FAS in 2011, which is when I started with Legal Aid Agency as well. So they are a scheme that hasn't formally existed outside of a couple of niche scenarios, high cost cases and exclusions from FAS for many, many years now, which just means that we have a smaller pool of caseworkers who have a full and detailed understanding of the scheme, because we don't need hundreds of caseworkers who understand the scheme as compared to FAS, which is pretty much the bread and butter of payments that we make to barristers under family. So yeah, the kind of key here is that there isn't a rate, but what you do with that is what we'll go over in the next couple of slides. So the baseline that we usually start with is what we pay a solicitor to undertake that work. And for family work, there's two rates tables that we'd look at in the remuneration regulations. And I've got a link here. So these slides are going to be circulated afterwards. There's a link here that you'll be able to click through to our Civil Finance Electronic Handbook, and it gives a really detailed list of what falls into what. But your two rates for family proceedings are Table 9A, and broadly speaking, that covers everything that is specified under Parts 4 or 5 of the Children Act 1989, and anything else is paid at the rates in Table 9B. I've listed some examples here of where you might see those. So appealing a care or supervision order, for example, would be Table 9A rates, or CAO residents representing the child, that would be Table 9B rates. Please do click on that link to the handbook to get a full and extensive list of the proceedings and where they would fall. But the broad rule is, if it's specified under Parts 4 or 5 of the Children Act 1989, it's Table 9A. Anything else, Table 9B. The other one, and a hot topic of discussion I know at the minute, is for deprivation of liberty, or DOLS. I've taken 3 different examples here about what would be claimable where. So first one, listed and heard together with care proceedings. This is quite a straightforward one. This is just related proceedings. So it's part of the care proceedings. It is amended onto the existing certificate for that client. And those are just paid at normal FAS rates because they are part of the overarching care proceedings. It's when they are listed separately or started separately and become merged later on, they become a little bit more complicated. Where they're listed standalone and heard entirely standalone, then your provider needs to ensure that they have, your instructing provider needs to ensure that they've sought a new funding certificate from Legal Aid Agency. We need to make a fresh funding decision on that and issue the client with a fresh certificate. They would be excluded from FAS, where you're doing those hearings, under provisions covering proceedings heard under the inherent jurisdiction of the High Court, and we would apply the Table 9A hourly rates. In terms of claiming, I'd love to be able to get some screenshots from CCMS to show you. Unfortunately, I'm also unable to get those screenshots for you. But in terms of getting to the right payment screens to access this, what I would say is you will find barrister own rate screens in CCMS. So as you're going through that billing journey, the first ones you'll come to, big header at the top of the page says barrister codified rates. There's a button that says remove, click that, and then click next, and it will take you through to a screen called barrister own rates, and you can use that screen to enter your own hourly rates to claim. So you can have a look in Table 9A, enter the right rate that you want to claim in that, and then click next, and it will take you through. And finally, you've got listed standalone and merged within care proceedings. So similar to the last one, in this instance, the provider must seek fresh funding decision. When the proceedings then become merged, from the point of merger, it would be related proceedings and paid under the care certificate. Anything prior to the merger, we can pay at the hourly rates under that standalone certificate. Again, this is all laid out in the handbook in detail as well, so that is a really good reference source if you're not sure. And again, if you do get really stumped on an individual certificate, just ask us and we'll do our best to help you to advise what the right rate to claim would be. Now, talking of hourly rates, one of the good things about hourly rates is there's provision to enhance them. However, when it comes to a rate that doesn't exist, there's no statutory basis for us to enhance it. You can't enhance something that doesn't exist. So what we would say is claim a higher hourly rate. The starting point, as I've listed here, the starting point is usually the rates payable to a solicitor. If the case then becomes complex or out of the ordinary, just claim a higher hourly rate equivalent to claiming an enhancement. So if the base rate was £54.90 and you wanted to claim a 50% enhancement on top of that, just add that all up to the total and claim that actual base hourly rate rather than trying to claim an enhancement. CCMS won't let you. The option doesn't exist in CCMS to do that because you can't enhance a rate that doesn't exist, and the expectation is that you just claim a higher hourly rate instead. What we expect when we see that is that the claim should draw the assessor's attention to any higher rate being claimed so that we can factor that into making an assessment. We'll consider the evidence in front of us and then either authorise, reject for more information, or reduce the enhancement claimed, and that would allow it to go to an independent assessor for a final adjudication if you disagreed with our decision. We cannot assume any higher hourly rate. You have to request it. We are the guidance and the contract and the regulations do not let us assume a higher hourly rate. You have to tell us. There is some helpful guidance here again. These are all links that you can click through to find the guidance and where it is. We've got the electronic handbook chapter 3. We've got the cost assessment guidance chapter 12, and we've got some interactive modules on CCMS as well. All of these will give you some idea about what is a good justification to claim enhancement, when you can claim it, what the enhancement might be as well. Some key things to remember is that from LEA's point of view, enhancement isn't a checklist. It isn't a case of factor A applies, therefore I get X percentage uplift. It is entirely discretionary within the guidelines that are available. And you could find that, for example, a single really complicated factor in a case, you could have some really complex child abuse factors, for example, or it could be an issue that's going to affect the roof over the client's head, again, for example, and that could be singularly complicated and on its own justify a higher enhancement. There isn't a magic formula for it. It's very much a case of gut feeling and justification that you provide us. You don't need to give us War and Peace. We don't expect a full treatise on why you've claimed a 50% uplift on the base hourly rate, but please do try to be specific and lay out specific facts of the case. The caseworker could be making decisions on maybe 10 different enhancements across 10 different cases in a single day, and you want to help that stand out by just making something short and snappy that helps the caseworker, as the assessing officer, understand why the rate is higher, and that's going to increase your chances of getting those costs paid. Another question that we get a lot as well is about the point of assessment. So this is what I would probably call the do-si-do that you need to do as the clerk between the instructing the provider and LEA to make sure that everything is lined up and all the bills come in at once. Fundamentally, from a regulations point of view, that's because we have one point of assessment at which we can make an assessment of the costs. Essentially, this is to protect the client in case of financial interest arises. It's to protect advocates from debt in case costs are awarded at the end of the case, and prevents an inconsistent assessment as well. And it's the same regardless of whether the bill is going to the court or to LEA for assessment. So we only have that one point of assessment, and that's why we kind of need that little bit of coordination. Admittedly, CCMS does not do it very well. We'd like to work on that when CCMS is back as a priority to make it a little bit easier all round for people. But the fundamental principle of it is because we need to do a single assessment. A really important point to bear in mind related to that as well is about payments on account. So I've just listed at the bottom here as well. What you may find, and Scott's alluded to this a number of times as well in his presentation, is that payment on account isn't a guarantee of payment on final bill. It is a payment on account of the final bill being due. We don't assess a POA. Our decision is essentially we will pay it or we will not pay it if we don't think it's eligible, because it's not the right payment window or something like that, and that would be prevented up front in CCMS. When the final bill is paid, the POA is offset against the final bill, and essentially the balance makes its way into your account. But we haven't assessed that POA, and that's why you can sometimes find that if you have perhaps overclaimed on a POA, you will get a recoupment when the final bill goes in for the difference between the POA and the final bill. That POA is not a guarantee of payment. It's just really important to note that. Next, I'm going to talk a little bit about the rates to claim on appeals. I've broken this down into 3 different parts, really. So we'll talk about the initial opinion, what to do with appealing an interim order, and then what to do with appealing a final order as well. So we start with the final order. Breaking it down into the 2 fundamental structures you've got for paying family cases. You've got your Family Advocacy Scheme, or FAS, and you've got your hourly rated claims as well. For Family Advocacy Scheme, it's a little bit more compact and controlled. You can claim an opinion fee after a final order is made on the merits and prospects of success of any appeal. That does not count as one of the two, the limit of two that is laid out under the regulations for FAS, and it would be claimable as an opinion fee for whichever the relevant scheme was that you were providing advice under. So you've got your 5 different matter types that cover FAS. Really important to note that because there is no opinion fees in domestic abuse, though, you can't claim an opinion fee for providing opinion on the prospects of success of appealing a non-molestation order, for example. But for a CAO residence order, then you could, and that wouldn't form one of the two, limit of 2 per proceedings, because it would be after the fact. For hourly rates, it's a little bit looser. Again, no fee is applicable, and we would apply the same hourly rate that we would for the rest of the proceedings that are being claimed as well, which will be determined on assessment. There's no limit to the number of opinions you can claim under these circumstances, but we would say, if you're claiming multiple opinions, that's the sort of thing that's going to be questions on assessment. So just be mindful of that as well. Likewise for the family advocacy scheme as well. Although you can claim that opinion, we would still expect to see a justification for why the opinion was being sought. If it was patently clear that there was no prospects of success and you knew that up front, then we may ask the question of, well, why have we gone through the rigmarole of doing this appeal when everyone knows that it's not appropriate, and is this a valuable use of public money? So there may be questions about justification even on the family advocacy scheme. So the initial opinion is pretty straightforward. When you start getting into the actual substance of doing the work for the appeal, that's when it starts getting a little bit more complicated. We'll start with interim orders. So I've, again, broken it down in here to family advocacy scheme and to hourly rates as well. Generally, appealing an interim order, it's going to be in scope of the certificate, so there's no need for your instructing provider to seek an amendment. But again, we'd want to see some sort of justification around why it was considered a reasonable step to take. Because it's part of the normal scope, any appeal of an interim order would be remunerated under the overarching FAS scheme that applied for those proceedings. However, as I said a couple of slides ago, anything heard in the Supreme Court or the Court of Appeal is excluded from FAS. So you can find yourself in a very niche scenario, but it absolutely does happen. We have seen it, where the proceedings overall fall into the fixed fee schemes, but because 1 or 2 hearings have been appeal hearings in the Court of Appeal, those specific hearings are remunerated at hourly rates because the contract's very clear and very specific that anything in those 2 courts is excluded from FAS, regardless of what the issue at hand is being heard is. So if that is the case, it gets those specific hearings only are excluded from FAS and brought into hourly rates. When you're claiming hourly rates, again, it's the usual script that the applicable rates are determined on assessment in line with the tests that we have been talking about over the past couple of slides. You'll find that hourly rates are split. We've got 2 levels, so you've got magistrates and county court and higher court as well. So from the high court up would be a higher hourly rate as well. And again, because it would be appeal of an interim order, no scope amendment is required to appeal. So even in these cases that fall under FAS, where they're being appealing an interim order in the Court of Appeal, then provider doesn't need to seek a scope amendment for that. It falls within the general scope of the certificate. And the simplest one, in many ways, is appealing a final order, because any appeal of a final order where you have got cover for it on the certificate is excluded from FAS. Regardless of the nature of payment for the original proceedings, it's all paid at hourly rates when it reaches final appeal. It's not affected by the level of court either. An appeal of an order from a district judge to the High Court would be hourly rated and not FAS, even though there are FAS rates for High Court proceedings. Again, as throughout, the rate applicable on assessment of costs will be determined in line with our usual assessment tests where we determine the hourly rates. And it's really important to note that any appeal of a final order, once the permission is given, it requires a fresh means and merits tested funding decision for public funding. So even an appeal of a care order that's been made, if it's final care order being appealed, that is means and merits tested funding, and that needs to be subject to a decision on an application. So it does need to be a fresh certificate at that point. And finally, talk a little bit about supporting evidence. And this is essentially the help us to help you get paid in full first time. We do not like rejecting claims. We much prefer paying them. It is easier around, it's less work for us, and it's less work for you guys as well. Overall, we did a lot of work before the outage to drive down our reject rate. So from March, April, May, before the outage, we were looking at a reject rate overall of about 10% of civil claims, which is actually the lowest it's ever been. You know, a couple of years ago, we were rejecting about 50% of civil claims, which is far too much. It's additional work for us that we don't want to do. It's loads of additional admin work for you resubmitting claims. We don't want to do that. We want to pay claims first time, and we did a lot of work driving it down to about 10%, which was really, really positive stuff. A lot of what we see on supporting evidence is really simple, and a lot of it is just keeping the simple bits and pieces in your mind when you're prepping these claims for payment. In terms of evidential requirements for FAS and hourly rates hearings, a couple of years ago, after lockdown, after the courts moved to a big wide-scale position of doing remote hearings, we were in a bit of a fortunate position because our guidance has always envisioned that remote hearings can take place, so we didn't actually really need to do much amendment because we already had provision to allow it, which was super helpful. But one thing that became really apparent to us was, obviously, with no one being in courts, no one can complete advocates' attendance forms anymore. So we needed to start thinking about what would be an alternative, acceptable alternative form of evidence, and we landed on the court order being acceptable. And actually, that worked for all parties, so we kept it. And we've not gone back to advocates' attendance forms. That doesn't mean you can't submit them. We'll still accept them. We've never decommissioned them. We see few and far between these days, of course. But generally, we will accept the court order as evidence for the hearing. But we do need some specific information in that to make sure that we're making a correct payment. We ideally need an approved order listing the hearing times and any bolt-ons or uplifts if applicable. If not, an attendance note is acceptable, but our preference is for a court order because it's obviously an official document. For advocates meetings, an endorsed brief and a copy of the approved order listing the meeting are acceptable. We are aware as well that particularly at the minute courts like to order advocates meetings before every hearing at the start of proceedings, and that's absolutely fine. Obviously, it does put advocates in a difficult position as well. So if you are being asked to take part in an advocates meeting, it's always worth asking your instructing provider if they've got the order that's listing the advocates meetings, even if it's that first one, made at the very first hearing, just so that we can see that we've got that evidence. Because if we don't get that to the end of the case, that you're claiming your advocates meeting after it's been undertaken, we don't know at that point. So actually, we need to see that order when you submit your claim for that advocates meetings. And conferences, we just need an endorsed brief or attendance note that confirms the time of the conference is separate to anything used to calculate the hearing, and ideally a brief note of what was discussed as well. For other evidential requirements for court orders, so this is essentially what we need to see in the round to make sure that all things are correctly claimed. So we've got the FAS information as discussed, but also there's other things that you may find your providers, your instructing providers are coming to you to ask, because this helps them in the long run of the case to get paid as well. In particular, we need to see evidential support for any experts' costs claimed, in particular drugs testing. Drugs testing is really expensive, so we just need to make sure that what we're paying for is what the court actually wants. You know, if the court has made an order for a very specific type of drugs testing, it's really important that list is listed in the order so we understand what the appropriate cost being incurred by the provider is. Likewise, if there's any unusual or specific apportionment of costs for an expert's fee, it's really helpful to see that listed in the order for the caseworker. It's really straightforward for them to then understand, right, okay, this party is paying this amount of the costs, I understand, and we can pay it. So we don't need to go back and ask any questions. And likewise, any specific or unusual disbursements as well. Transcription fees are perfectly recoverable costs, but because they're quite unusual, again, we need to see that the court has required or requested that information. So it's really helpful to see those in the court order. And getting that right first time can obviously just help reduce administration time for both yourselves and for your instructing solicitor, and it helps us pay claims first time as well, which is what we're all here for. I thought it would be really helpful to share this slide with you as well. So these are the recitals for FAS timings. So this is the specific wording that we have shared from LAA with the judiciary to request that this is the sort of thing that we need to see in the court order to justify any FAS times claimed. It's not mandatory, but it is really helpful for us. And we've shared that in a document called the Family Advocacy Scheme Information for Judiciary, which we did draft in conjunction with, in particular, the Association of Cost Lawyers, to just help judges understand why it is that we are asking for this information to be put in the court order. It's because it helps us get rid of the need to have another form with a load of tick boxes for people to fill in, scan in, upload in CCMS as well, and they can just put it all into the order instead. So this is our recommended wording that we have shared with Judiciary. It is here for you to copy and put into draft orders as well if you think it would be helpful. And finally, I'll just touch on evidential requirements for disbursement as well. So in particular, as barristers, I think you find travel to court will be a disbursement that is something you might be looking to claim. What we would expect to see is the journey from chambers to court exceeds 10 miles. That's laid out in our guidance as the local travel rule. And we may check to see if there was a more appropriate bar available for longer journeys. You know, we completely accept that sometimes you need specialist counsel to travel across the country. That's absolutely fine. Please give us that justification though, because otherwise we may do a check to say, okay, well, if you're based in Liverpool, why have you instructed my counsel from London when there's a bar in Liverpool, there's a bar in Chester, and there's a bar in Manchester as well? If you can give us that information up front, that's really, really helpful as well. We can pay any method of travel, but generally we consider public transport to be a more cost-efficient method of travel than car, or in particular taxi as well. Now, that's not to say a taxi isn't appropriate. You know, if you don't drive and you've got several boxes of papers that you need to take to court, a taxi could be a justifiable cost. But please tell us, because the guidance is really clear that our default position is that we won't pay for taxis unless it's got a specific justification. And the ticket itself is justification in this instance. So if you travel by train, please try and retain a copy of the train ticket, because we can use that as evidence to reimburse you for the cost of the train ticket. The other one is overnight costs as well, which are, again, unusual, but completely justifiable if specialist counsel is required. We have costs limited per cities, and that is a larger amount in larger cities as well. They generally tend to be more expensive. And you can claim subsistence alongside an overnight stay, but it is limited to a maximum of £25 per night. Obviously, we're not going to pay for cigarettes and alcohol either. It specifically does need to be for food. And all costs need to be evidenced with receipts, invoices, or any other evidence, which is just basically so we can demonstrate to the National Audit Office that we've considered that a financial transaction has taken place. So that is the end of the slides I've got for you today. So I'll pass back over to Shiva now, and I believe we're going to move into the Q&A session.
Thanks very much, Rob. That's really helpful. It's particularly helpful to hear the evidence that we need to provide so that we get paid first time round. So yes, we're open now for questions, and please feel free to post your questions again into the questions and answers box. No question is a bad question. These are complex rules, and the regulations are not straightforward. You might have come across situations that you just want to run by your very experienced panel. So please do take the opportunity to post your questions, and they'll do their very best to answer them. We've got a couple of questions to start with. The first question is a question that has come in advance. Scott, I think you've agreed to take this question. So with the current uplift in hourly rates for high cost and complex family cases, what best practices do the Legal Aid Agency recommend to ensure transparency and currency when claiming enhancements and special preparation payments, SIPs? That's the first bit. The second bit is, how should we prepare interim case plans to maximise the chance of approval, Scott?
So I think I covered bits of this in my slot, but I think for SIPs, that's put it in the order. The LAA won't reduce it if the judge has ordered it. It's the same as with the SIPs form. As long as that's been certified by the judge, you will get paid it. So that's a winner. In terms of uplifts for hourly rates, I was typing notes as Rob was speaking because I had some ideas, and I went and visited Rob, because Rob and I are both in Liverpool, based in Liverpool, not far away from each other. So I went and visited some of his team and sort of chatted to people about various different things. And the people who assess the hourly rates cases, I was talking to them about the justification that council provides, and they were saying it's really annoying when you get a great big long spiel, and the first half of it is how many times counsel appears in the Legal 500 and Chambers and Partners. It's not relevant to the LAA when they're assessing this claim. What they want to know is, what's the case about? Why is it complex? What did your intervention in this case mean, which meant that we can now pay you a higher rate? And so we were bouncing some ideas around it, and so I said, "Oh, I had a case which was a court protection case, and council hadn't really provided any justification. Those fees clerks that are on the line will know what I'm talking about. So I had to little scroll through the case summary to find out what the case was about, and it looked pretty straightforward. I thought, oh, maybe it's just one of those ones, and then I saw this one sentence. And it was a 70-year-old woman and a 75-year-old man, her brother. They were living together, but they'd taken the mum, the lady into care. And the concern was that they were brother and sister and they were having sexual relations. And that hadn't appeared anywhere else. And that was and as soon as I mentioned that, they said, yep, that's an uplift right there. That's a key factor. That's important. That's complex. We understand that needs, council's intervention. So what I would say is caseworkers aren't lawyers, generally speaking. If you start, I mean, they pick stuff up like we do as clerks, but they won't, think about the subtleties of you. If you're talking about the type of legal argument that had to be run in this case, that won't mean a great deal. But if you can explain what the facts are, and really it's a bit sort of sensationalist. If you give the horrible, some of the horrible cases, the sexual abuse cases, the things that we see, they're the ones that grab the eye. So I would go facts, and then why it's important. The Civil Electronic Handbook and the Remuneration Handbook have some brilliant guidance on how to claim uplifts, and there's a sort of a key sort of tick boxes, the urgency, the complexity, the importance to the client. Look at those. They're really, really, really useful. They are technically for civil cases, but there's a sort of bit where it says in the bit for family guidance, it said, see this guidance. So you can use bits of that for family cases, and I think that's where you really need to go with it. I think also understanding that sometimes there's a breakdown in communication. So I was speaking to the high cost team when I was up in Jarrow, and I was talking about this problem with hourly rates cases. They're kind of pootling along. You get paid at certain rates for certain types of cases. The LAA will approve them. It goes high cost, and then the high cost team are hammering you down and everything. You think, why is this happening? So we were talking about it, and they said, quite often the solicitors can't submit the fee notes for council because there's outstanding fees that council hasn't billed. And as clerks, we put the justification for the higher rates on the fee notes. So if that piece of information is missing, the high cost family team are looking at us going, well, there's no justification for why you want higher rates or why you're claiming for 20 hours prep. So they mark it down. So that's a key one, is a bit of a sort of communication issue. So make sure that the solicitors have your justification, have your fee notes, and it's included with the case plan when it goes in. I think that's absolutely key. Don't know if you've got anything to add to that, Rob. Anything?
I think that's broadly covered it, Scott. I think your point about remembering that caseworkers aren't lawyers is really, really helpful and really valuable to remember as well. Yeah, absolutely. We'll pick up bits and pieces as we're going through, and the more we do things, and more cases we assess. But yeah, keep it simple, keep it snappy, and just draw out the facts, the key facts for caseworkers about why this specific case was complicated. And that's your best guarantee for getting your enhancement ingredient on your case plan as part of your bill that you're submitting as well. I always say that assessment of costs is an art, not a science, and it's about gut feel and knowing the facts and knowing the evidence, and it really helps us where you can just lay that out for us, because it just makes arriving at that conclusion a lot simpler as well. So yeah, key thing to remember really is that caseworkers aren't lawyers. Otherwise, they would be lawyers and not caseworkers. And if you just remember that while you're writing down your justification for your enhancement, that's really, really valuable.
Yeah. I think also, I mean, for the clerks in the room, that you'll have barristers in your set that will charge 10 hours prep for a case, and another barrister on exactly the same case will charge 30 hours. And why is that? It's the experience. It can be just the way they retain information, be all sorts of things. So the LAA get these conflicting bills, and they're looking at them. So that sometimes they're going to be thinking, well, we need to reduce that because that's far too much. If you start to build a picture of what these cases, how long these cases take, so then you get these weird differences. So it is all about that justification, making sure that you make the point as to why you're claiming what you're claiming. It's absolutely key.
Thank you both very much. Next question. So it's a scenario question. In a care case, Casey and the junior were instructed to represent a client at a 10-day fact-find hearing. Due to the judge being ill, the hearing was postponed for a few days. The KC wasn't available to represent the client at the new dates. A new KC was instructed. How are the previous KC and junior counsels fees claimed, and can both the KCs claim fees?
Yep. Oh, that'll be me, definitely me, that one. So, assuming if this is an events case, because it's a 10-day fact finding, assuming there's going to be a final hearing after that, that would take us over the 11 days. So we're events. Then normally when a case is relisted, the underruns aren't claimable if the hearings are relisted, because it's basically the same hearings. But in a case where counsel has to be substituted, and this quite often happens with KCs, the LAA will pay you the underruns for it's effectively wasted preparation for the KC who's no longer able to act. You do have to justify it. You have to explain it. It's no good just putting a bill in. Otherwise, the LAA will look at the regs and say, you can't claim it. So you've got to explain why you're claiming what you're claiming. If it was an FGF case, which it could be, I mean, if it was a 10-day fact finding and there was never a final hearing afterwards, it's potentially that it could have been. Then only one F5 primary is claimable, but you could still claim special preparation. There's no underruns for FGF, so that wouldn't count. But I think that it would almost definitely be events, and in which case the original KC who was replaced could claim the underruns. So yeah, there's no problem claiming, I think.
Okay, thank you very much, Scott. The next question is, when is it acceptable for overnight stays to be claimed?
Definitely Rob.
Yeah, it's a really good question as well. How long is a piece of string? It depends on the appropriateness of the situation, particularly for barristers. So, if you are based in Manchester and you're covering a hearing in Liverpool and that hearing lasts 2 days, we would say, is that justifiable? Probably not, given the ease of travel between the two cities and the cost of travel between the two cities being significantly cheaper than a hotel. But if, for example, you've been called from Manchester to do a hearing in Newcastle that's lasted 3 days, Newcastle upon Tyne, let's be specific, that's lasted 3 days, then yeah, that would be specific. That would be a justifiable time to claim a hotel fee. What we'd need to see in that instance in particular is why it specifically needed to be that counsel. Specialty in particular is the sort of thing that we'd be potentially looking at to understand why are we incurring this additional cost? Why was a suitable barrister not available in Newcastle to cover this? That's the kind of understanding that we'd want to have on assessment to make sure that we were paying the costs correctly. In terms of evidencing it, it's pretty straightforward. We just need to see the invoice from the hotel to see the costs incurred. A hotel in Newcastle, I can't remember the specific rate, something like £100 a night now. It went up at the end of last year. But generally, it's again, it's not like a tick list. X scenario has been met, therefore overnight can be claimed. It's very much case specific, and the sort of factors that we would be looking at is to see, why was this the most cost-effective way of dealing with this hearing? Why was the speciality of this counsel in particular needed over any other one? It's just a run-of-the-mill contact case, for example, bringing a solicitor, bringing a barrister in from Birmingham to cover a hearing in Carlisle. That's the sort of thing where we'd have to question of was someone more local not available to reduce the cost? But actually, overall, we do accept that there are scenarios where they're going to rise, and we're quite happy to have those on assessment to understand and make a judgment call on if we think it's appropriate or not.
I think it's worth saying as well that continuity. So if a case has been transferred from the home court and counsel's dealt with it throughout, there's a need for continuity for the client. KCs is a good one because there are a limited number of family KCs in the country. So if you can't find one in your hometown, it's perfectly acceptable to go elsewhere. Though you do have to justify it, as Rob said. That is, you've got to use your local silks first. We are available. I've got 6 in Manchester and Liverpool and Chester. Just floating that one out there. Leeds, Sheffield, we're there. Quick pitch.
Thanks very much, both. Yeah, just on the back of that point, on the travel, I've got a case where I'm going to be up in Liverpool for 3 weeks, and obviously the first point that we had to deal with is why me from London, and the simple answer, as others have said, is if there isn't local bar available, there were no local silks available, or even silks in the north for those particular dates. So all 3 silks in that case are having to travel from out of the area. So easily justified, and there's no difficulty with our overnight expenses being paid.
I think that's because all of my silks are in a 5-week case at the same time.
Okay, so next question. This one's directed to you, Rob. Question is asking, is the application process for CCMS going to remain the same when Legal Aid Portal is up and running again?
Yes, really nice and simple one. No, it is. What you will find is there may be some differences in the functionality of your actual account, which is a result of being onboarded onto the new system, or the new portal, or rather Silas. I guess the way of thinking about it really is that the house is still there, CCMS. It's just the front door has changed, and when you get through the front door, you will find that CCMS is going to look the same, and its functionality is going to be the same as well. There will be no surprises there. The changes will be about potentially linked to your individual account and what your individual account is able to do. But the application process itself, or the claiming a POA, claiming a bill, assigning cost to council, all of those bits and pieces are going to look and function exactly the same.
Okay, thank you very much. The next question is, are fact-find hearings billed as interim hearings? If so, why is there not an enhanced fee because evidence is heard?
So I can do this. So it depends. So if it's a high cost events case, or a high cost case in general, it's slightly different in that the way the case was listed determines it. If it's FAS, it has to be listed to be dealt with as a fact finding and be effective as a fact finding. So if you turn up on day 1 and the case all goes a bit pear-shaped and the judge says, oh, actually, we'll just deal with this as a couple of, and you have one of those weird things where you have 3 days of interim and mucking about and they're effectively case management hearings for 3 days, then that is not a fact-finding hearing. It wasn't dealt with, evidence wasn't heard. That can only be claimed as an interim. But if it's a fact-finding hearing in public law and private law is treated as a final hearing, it's paid at the same rates as final hearing, providing it's effective as a final hearing, as a fact-finding hearing, and it works in the normal way.
Yeah, that's quite right, Scott, as well. What you'll find as well is that sometimes a fact-finding hearing will segue directly into the final hearing as well, in which case we would consider it's all part of a single hearing that's been split. You know, there may have been directions in between with several weeks. That's completely fine, but we would potentially consider that a single hearing with a split in the middle of it as well. So it would all, under FAS, add up to, you know, however many days it was, 4, 5, 6 days, as long as it was. And in private children as well, in particular, I believe the contract says that where the finding of fact wraps up proceedings, it can be claimed as a final hearing as well.
Thank you. Okay, the next question is, if a hearing is listed as a DRA, but the case concludes with a final order, why can't it be billed as a final hearing? There's only one final hearing.
That's me too, I think. So it can. Simple answer is it can, and but it can only be claimed as a final hearing if the certificate has been extended to cover final hearing. If it hasn't, you can only claim it as an interim. And unfortunately, in private law children cases, it would be unusual to have cover extended to final hearing before the DRA, because you'd still be waiting for reports and things, CAFCAS and whatever. So it's likely that cover wouldn't be extended, so you wouldn't be able to claim it. But technically, if a DRA concludes a hearing, then you can claim it as a final hearing, providing the certificate's been extended to cover it. And I would put a big shout out here for the Civil Electronic Handbook, because questions like that are in it. They're brilliant. The Civil Electronic Handbook is my Bible. The minute I have a problem, I open it, I do the F5 to search, and in I go, and it's brilliant. If you did that, if you did the search box and type in DRA, I guarantee you it'll take you to that. So it's really handy.
Yeah, shout out to the handbook, particularly the enhancement chapter. I enjoyed that, Scott, because I'm not going to lie, I wrote that.
Okay, great. The next is another CCMS question. When CCMS is back up and running, what will the process be like in terms of processing bills?
So I'm assuming this isn't from the point of view of yourselves in terms of submitting the bills, it's going to be exactly the same. Everything should look and function exactly the same. We have tested the bulk claim upload feature in CCMS and it works as well. So we are pretty confident that when CCMS is up and running, whenever that may be, hopefully in the next couple of weeks, that the experience you have in terms of submitting bills will look exactly the same. In terms of our end as well, I will say a big shout out to Scott and some of his colleagues as well, who we have really good conversations with about what priorities are going to be on restoration of system access for you guys in terms of bill submission. That's really helped us stand up our additional resource into the right places to make sure that we can deal with claims. And we are very confident that we will be able to turn around, in particular, payments on account and family advocacy scheme payments to barristers and high cost cases. We are going to be able to turn around in near as we can to pre-outage times. So for POA, 1 to 2 days, for a fast payment, 2 to 3 days, and for a high cost payment, 3 to 5 days.
Thank you very much. Okay, next question. If we have a door tenant from London instructed on a case via our chambers, we are not a London chambers, do we still claim London council rates or is it regional?
So it's the court, isn't it, Rob? It's not where you're located, it's where the court's located that determines the rates.
It's the, we might need to go away and check this one, because generally it's the location. If you're a provider, it's the location of the provider. So if you're based in London and doing a domestic abuse case, but you're covering you're a national firm and you pick this up in Birmingham, then it will be paid at London rates. So door tenants is an interesting one. I think we might have to take that one away and have a look at it. I think it's where the barrister is based. So if they are based in London, then I think they would get the London rates.
Okay, thank you very much. The next question, are appeals from fact-find hearings treated as interim appeals or final appeals?
Final. They are treated as final appeals, so they'll be paid on hourly rates. But it's effectively a final hearing. It's a very, very weird one. But yeah, they are treated in the same way that final appeals are. And you invariably have to go to the Court of Appeal for that sort of thing.
Which would make it hourly rates either way.
Yeah.
Okay, I think that is the conclusion of our questions. Nothing else is in the question and answer box. So we're going to draw the seminar to a conclusion, and all that remains is for me to thank our panel, and we're very grateful indeed for Scott and Rob and Catherine and Nick for taking the time to attend this. Scott has been assisted in the background by his two colleagues, and we're very grateful indeed to all of you for the wise words and knowledge that you've shared in this seminar and breaking down the information in a way that's understandable, and for putting the time in to provide really useful handouts that will be available to everyone that's attended this seminar. So our deepest gratitude from the Bar Council for doing this work. It's really useful for practitioners to be able to hear directly from you. We want to thank everybody who has attended this evening. We hope it's been useful to you, and we're bringing the seminar to an end. The handouts are available. We haven't got any questions outstanding, which we sometimes do have, which our panel always are very generous with responding to afterwards, but I don't think we're in that situation today. So I wish you all a very pleasant evening. Thank you and goodbye.
Thanks all.
Thanks all.